Hi, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. Today I'd like to talk to you about unlawful orders. Unlawful orders have been an issue since as long as I've been a prosecutor, over 30 years now, and it pops up periodically. While I was still the district attorney, an assistant sheriff was directing homicide detectives to arrest suspects when they did not believe they had probable cause. That same assistant sheriff was ordering robbery detectives to execute search warrants when they did not believe they had probable cause. And so this policy that is found at 4/104.02, titled Unlawful Orders, was enacted in July of 1973. So you can imagine how long this issue has been in play. Periodically we have captains who get their rear ends chewed at action meetings, and it goes downhill from there, and sergeants and lieutenants are directing officers to make arrests. It is important for you to understand that if you are given an unlawful order, you are putting yourself in jeopardy if you follow that order. So for example, if a sergeant or lieutenant tells you to make an arrest and you do not believe you have probable cause, you can't execute that order. You can't arrest that suspect, because otherwise you will be in federal court facing a 1983 action for violating the individual's civil rights. And so let's talk about 4/104.02. That statute says that no member is required to obey any order which is contrary to the laws of the United States, the state of Nevada, or the ordinances of the county of Clark or the city of Las Vegas. That means if you are being requested or ordered to make an unlawful arrest, or you're being ordered to execute or obtain a search warrant without probable cause, you are on the hook, regardless of the order. And the ordinance goes on to say, refusal to obey an order is the member's responsibility, and he shall be strictly required to justify his action. Here's something key. Obedience to an unlawful or improper order is never a defense for an unlawful or improper action. That means that if your sergeant tells you to make an arrest without probable cause, you're on the hook too, both as far as civil liability is concerned and department policy. So what do? The ordinance or the policy goes on to say, any member who is given an unlawful or improper order shall, at the first opportunity, report in writing the full facts of the incident, together with his own action, to the division/office commander through official channels. So let's take a hypothetical. Let's assume that you're out there patrolling, and you respond to a DV call. A supervisor tells you to make an arrest and you do not believe you have probable cause to make the arrest. It is your obligation, according to this policy, to not make the arrest and immediately go back to the station and draft a memo to send up through the chain justifying your order. So you have to be careful. Obviously, you have to make very sure that the order is unlawful. But if you firmly believe that the order is improper or unlawful, then don't do it. You can always contact PPA. We have a 24-hour call. You can talk to a rep while you're out in the field, and they will dispatch you to me if appropriate. But once again, take a look at 4/104.02. It gives you the option to get out of an unlawful order without having to place yourself in jeopardy. Thank you, and as always, if you have questions about any legal issue, whether it's criminal or otherwise, contact me at the PPA office at 702-384-8692 or email me at droger@lvppa.com. Remember, I'm not a department employee, I'm your lawyer, and we have an attorney-client privilege relationship. Thank you.